In this video, we're going to examine the Court of Appeal verdict related to the Lucy Letby case. This relates to the original trial in which Lucy applied for leave to appeal, which, as we know now, was rejected. There is another Court of Appeal verdict related to the retrial that I'll probably examine in the foreseeable future. The first thing to say about this judgment is that the first 29 paragraphs are basically irrelevant. They just outline the facts of the case. They don't examine the leave to appeal or any of the details related to this. So when people say it's a 57-page judgment, the first 9 pages are basically completely irrelevant to that judgment. I also want to mention that I'm not going to discuss Professor Arthur's in this video because he repeatedly stopped short of claiming that X-ray imaging could establish how gas had entered the circulation of infants. Of course, as we know, it was present in numerous infants and it can be present for inadvertent or accidental reasons, particularly when ventilating babies. So Professor Arthur's is beyond the scope of this discussion of the Court of Appeal judgment. In this Court of Appeal judgment, paragraph 42 establishes something important, which is that Dr. Evans stated irregular breathing, cessation of breathing, alterations in temperature or variations in heart rate, reduced heart rate or increased heart rate are common features that signal deterioration irrespective of the cause. Resuscitation is usually effective. If the infant fails to respond, one usually can find a cause in the form of overwhelming infection, severe hemorrhage, or total systems failure. It is therefore concerning and unusual to discover an infant failing to respond to standard resuscitation procedures and where investigations after the death fail to identify an obvious cause of death. So this is kind of the template on which Dr. Evans relies for his so-called air embolism diagnosis. Part 1. Discoloration. Discoloration is a critical component of the trial that is referenced frequently with regard to multiple infants during the court case. It is memorably established here. This is the first reference in relation to child A where doctors observed an odd discoloration on child A's abdominal skin, flitting patches of pink over blue skin that seemed to appear and disappear. Now, there are numerous problems with this observation, and perhaps the most obvious is that it wasn't recorded at the time. This is based on the memory of Dr. Jayaram, as we're going to discuss as this video continues. But what I'm going to critique in this section on discoloration is the validity or otherwise of the Court of Appeal judgment. So in paragraph 139, we see this reference to child O. I'll read this in full. Says that the description of skin discoloration did not feature in Dr. Jayaram's clinical notes. We observe in passing that there appears to have been little evidential basis for the allegation implicitly made on behalf of the applicant that Dr. Jayaram had made up this part of his evidence. We also note that no similar allegation appears to have been made against the father of child O, who was set at para 93 above, described his child's veins as being bright blue. So firstly, we don't know how the description of Dr. Jayaram suddenly appeared when it wasn't in the clinical notes at the time. We do know from the case of child K that Dr. Jayaram doesn't necessarily have the most sparkling memory. Secondly, child O's father is a completely different witness, describing a different baby at a different time in different circumstances. The fact that nobody alleged that he invented his observation does absolutely nothing logically to establish whether Jayaram's later recollection was reliable. This is an introduction to the sort of strange reasoning that features prominently in this document. So we'll now move on to paragraph 71. And this is an extensive discussion of Dr. Jayaram being challenged by Ben Myers in court. And Jayaram claims that he was not aware of the clinical significance of the discoloration at the time. It's only in June 2016, after supposedly unusual, unexpected, and inexplicable events, that he began to look for explanations and found this Lee and Tanswell paper. So it's worth bearing in mind that 12 months have passed, A year has passed since he supposedly witnessed this discoloration, so there have to be serious question marks about whether or not this is legitimate. I mean, I obviously don't think it is legitimate, but someone else could suggest that he's managed to remember it accurately for 12 months. Never mind the fact that it doesn't match the actual discoloration that's required because it's flitting, so it's appearing and disappearing, according to Dr. Jayaram, whereas the discoloration needs to be transient, not flitting. In fact, this is a classic post-event memory contamination issue, not an allegation of fabrication. Reading a distinctive description before formalizing a recollection creates a methodological reason to compare that recollection carefully with contemporaneous notes. It doesn't automatically mean that Dr. Jayaram's observations were incorrect, but obviously if 12 months have passed, it was an extremely traumatic event, there was a lot of urgency at the time, there wasn't time to make proper observations, there definitely wasn't time to note it down, then there have to be serious question marks about the validity of these observations. Now, the Court of Appeal verdict here is hiding behind the suggestion that the defence was saying that Dr. Jayaram is lying, and we can't see any reason why he would be. Okay, there's a few more reasons for that now, but they weren't actually necessarily either explicitly or implying that Dr. Jayaram was lying. What they were saying was his recollection of this incident is mistaken, and it cannot be confidently or even credibly relied upon. So moving on to these two paragraphs 145 and 187. Now, these contain what I believe to be the deepest scientific logical weaknesses of the Court of Appeal verdict, treating consistent with as affirmative evidence without adequately asking how discriminating the feature is. The court accepts that the various skin discolorations were not diagnostic of air embolism, but its answer to this is that they were nevertheless consistent with air embolism and could therefore form part of the so-called circumstantial case. But something being consistent with a hypothesis does not necessarily provide meaningful evidence for the hypothesis itself. It is important how commonly the same observation occurs under alternative hypotheses. A temperature, for example, is consistent with infection. It is also consistent with many other conditions. If the feature has little ability to discriminate embolism from ordinary circulatory collapse, and we know, for example, that discoloration is common with circulatory collapse, accumulating it with other weakly discriminating observations does not then magically turn it into a diagnostic marker. This judgment never really confronts this major diagnostic and probabilistic problem, not least because the judges have no scientific basis or knowledge on which to do this. So paragraphs 145 and paragraph 187 waffle on for quite some length about the basis of skin discoloration. So, for example, it's stated here in paragraph 187, the core of the proposed evidence is that, save for that one very specific form of discoloration, it would be wrong to diagnose air embolus on the basis of skin discoloration alone. But that's not really what's being argued. What is being argued is that the skin discoloration was the only diagnostic criterion that would have any merit at all, and that the skin discoloration that was seen in the court case is not the type of skin discoloration that is required for air embolism. Should also add that we shouldn't see discoloration anywhere near as much as it was cited in the court case, because statistically it should only occur in approximately 10% of cases, whereas here we know it occurred in 93% of cases. The other factors that are supposedly used diagnostically are basically worthless because, as I've described previously, they also apply to hundreds of other conditions, and indeed air embolism is one of the least likely conditions in which these so-called diagnostic criteria are present. So paragraph 151 is also troubling here, where they're talking about ground 2. We would add that the applicant herself, when giving evidence, raised the possibility of alternative explanations for the collapse or death of individual babies, but did not give affirmative evidence of an alternative cause. It seems to me that this is an utterly ridiculous expectation. I don't see how it can possibly be considered a legitimate aspect of the court case that Nick Johnson, after the police have already done this as well, Nick Johnson puts Lucy Letby on the stand. Well, obviously the defence have done it and he's cross-examining her. I guess it's not fair to blame him for her being on the stand or in the witness box. But then he expects her to explain everything in the court case. And then the Court of Appeal cites the fact that she wasn't able to give affirmative evidence, as they describe it, as reason, as if this is somehow troubling. Now, it'd be pretty difficult for her anyway if she hadn't been incarcerated in a maximum security prison for 2 years prior to the trial. But this is an extremely odd observation in any criminal case. The fundamental question always, let's not lose sight of this, is whether the prosecution evidence establishes deliberate harm sufficiently reliably. The defendant obviously does not have to establish the true natural cause of an unexplained collapse. It does not. This essentially is formally reversing the burden of proof. It risks making the whole judgment about the defense couldn't tell us what happened either. But that's not the job of the defense. It's not the job of the defense to prove innocence. It's the job of the prosecution to prove that their case and the components of their case can be proven beyond reasonable doubt. So the fact that Lucy, in the witness box, did not give quote-unquote affirmative evidence of an alternative cause, this shouldn't even feature in this judgment, as far as I can see. Now, we're going to switch to paragraph 182 now, and this contains what I think is an extraordinary piece of intuition or assertion. I'm not quite sure how to describe it. I'll read this paragraph to you in full. It is not clear to us why a discoloration which was previously treated as consistent with air embolus is now said to be specifically diagnostic of air embolus. Given that many of the rare cases of air embolus in neonates are likely to occur in neonatal units, and given that the 2 studies referred to by Dr. Lee collectively refer to well over 100 cases of acknowledged air embolus, it is to the layman surprising that in the last 35 years, only 1 or perhaps 2 cases have been reported of these specific bright pink vessels against a generally cyanosed skin. For present purposes only, however, we shall assume that Dr. Lee's opinion as to that particular discoloration is correct. Now, this is a remarkable assertion. They accept that Dr. Lee is eminent, and he explains his position concerning the specific cutaneous sign, and the judges then observe that it's surprising to the layman that only 1 or perhaps 2 examples of this particular appearance have been reported in the published air embolism cases. But actually, the original Lee and Tanswell paper and a later Lee and Tanswell paper, well, sorry, it's not authored with Tanswell, is it this time? Authored with, I think Zhu is the name of the other doctor. They both outline the cases of the Lee sign, and they both conclude, quite rightly, that it's a rare sign, and that is why it cannot be used as solely diagnostic, because it doesn't appear in the majority of cases. So you can't say either there is no discoloration, there is no indication of the Lee sign, therefore this is an air embolism, and you equally can't say there is discoloration, therefore this is an air embolism, because it has to be this very specific type of discoloration that we're going to discuss later in the video. That is baked into the cake because there's a very specific biological explanation for that. So it seems to be a misunderstanding from the judges that presided over this, whether disingenuous or otherwise, whereby they seem to be saying there was a lot of discoloration and an expert's come into the court and said that's air embolism, and Dr. Lee hasn't seen his sign very often, so therefore it's somehow doubtful or somehow dubious, when the reality is that loads of different signs of general discoloration and which are typical of circulatory collapse have been used in this court case incorrectly, because they're not the Lee sign, which is the only sign of discoloration that is associated with air embolism. I'll explain that later. So lots of signs of general and localized skin discoloration have been used as diagnostic of air embolism, which is just a palpable error. For some reason, the Court of Appeal can't understand this. And I would say that it's a rather remarkable sentence in an appeal concerning the reliability of specialist scientific evidence. Whether a rare physiological manifestation ought to have appeared more frequently in published case reports is a scientific question, affected by prevalence, recognition, reporting, documentation, case selection, and biological factors. Judicial intuition about what seems surprising to a layperson isn't evidence or even of any relevance at all. Importantly, the court does say it will assume that Dr. Lee is correct, so the remark isn't ultimately the basis on which his evidence is rejected, but rhetorically, it is, I think to be generous, an extremely odd and inappropriate thing to even include. Paragraph 190, which you can see on the screen now, risks what you could describe as evidential bootstrapping. So I'll read this out in its totality as well. For that reason, we see considerable force in Mr. Johnson's submission that the evidence relating to baby A illustrates why the applicant's approach is misguided. The evidence showed that in life, baby A had air bubbles in his brain and lungs, and immediately after his death, a lot of air was found in his great vessels. All those findings were consistent with, though not diagnostic of, air embolus. So, before I just finish reading this out, another thing that we see that I've already mentioned, but we see this throughout this Court of Appeal judgment, is that they keep repeating this idea that something is consistent with air embolus, but it's not diagnostic of it. So the reason that has been stated and is stated is because Dr. Evans said that himself, because there is nothing solid in his diagnosis. Air embolism is a very specific diagnosis. It's not something to be put in place because other things have been excluded. It's not something to be put in place because there are some generalized conditions. It's not something that you put in place because you can't find another explanation. It's a very rare and very specific diagnosis, so things shouldn't be consistent with air embolus. They should be explicitly diagnostic of air embolus. But yet, consistent with does an enormous amount of lifting in this particular document, and it shouldn't. So I'll finish with this reading of this paragraph. Baby A collapsed and died in circumstances very similar to those of his twin sister the following night. The applicant was present on both occasions. There was ample evidence on which the jury were entitled to find that she had poisoned 2 other babies with insulin. In short, the circumstantial evidence and medical evidence has to be considered in its totality, not reduced to a single issue as to skin discoloration as a basis for diagnosis. So, an incredible paragraph that's essentially completely lacking in logic. When explaining why Dr. Lee's challenge to the air embolism evidence does not undermine the case concerning child A, the court invokes the air seen radiologically, similarities with baby B, Letby's presence at both events, and then adds that there was ample evidence that she poisoned 2 other babies with insulin before talking about circumstantial evidence. Legally, the jury had been permitted to consider evidence cross-admissibly, so the mere fact that the court considers other counts isn't necessarily legally improper. But there is a serious danger of inappropriate reasoning here. If the medical evidence for one alleged method is weak, evidence supporting another alleged method cannot repair the scientific weakness simply because the same defendant is supposedly on duty at the same time. This is essentially a structure becoming self-reinforcing, or it's also could be described as a circular argument. So you have a situation where air embolism looks more likely because she was supposedly an insulin poisoner. Insulin poisoning looks more incriminating because she's linked to the other suspicious collapses. Those collapses look more criminal because she was an insulin poisoner. The circumstantial and anecdotal evidence looks more convincing because of the other. It's just a closed loop of suspicion in which the manifest problems and weaknesses of all the individual items of evidence are overcome by them all being linked together. And then in this Court of Appeal verdict, they say, oh yeah, no, well, maybe this is bad evidence, but hey, what about the insulin evidence? And then when you look at the insulin evidence, it's like, hey, but Lucy was always on duty. And hey, that statistical case is no good, but hey, what about the note? Okay, well, the note's no good, but what about the insulin cases? But we've already spoken about the insulin cases. And literally that's what happens in court cases. And then the barristers get patted on the back and pray, oh, look at the way they masterfully weaved all this together. That the fact that none of it has any evidential, scientific, medical basis or credibility whatsoever doesn't seem to matter. So the next paragraph I want to look at is paragraph 131. This is a very lengthy, and even this is not the whole paragraph, so I'm not going to read the whole thing out. But in this, the judge accepted limited literature direct experience, but considered evidence admissible, noting that imaging, pathology, and broader circumstantial evidence were available, and that no single non-diagnostic medical sign had to determine the case. It's another aspect of circular reasoning. Yeah, okay, this evidence isn't very good. The so-called proof of air embolism isn't there, but hey, there's broader circumstantial evidence, and there's a bit of this and there's a bit of that. We mix it together. Now, anyone that's baked a cake knows that if all the ingredients are crap, you get a crap cake. But that doesn't apply in the court, where you're allowed to scientifically ignore what is sound reasoning and bring together all of these individually worthless strands, and then say, hey, but you haven't examined the way that all of these strands link together. But all of the strands don't have any merit. So by definition, the case has no merit. But you see in the Court of Appeal that they just repeatedly say, yeah, okay, well, this isn't very good, but what about this? So we can't rule it out on this ground because, no one's saying that Lucy Letby was convicted on this ground alone. What about these 5 other things that are also crap? And I suppose what we should say finally is that circumstantial evidence that could conceivably identify a perpetrator does not increase the intrinsic diagnostic specificity or value of a skin sign or radiological appearance for air embolism. And the fact that such assertions are made in this document on several occasions, in fact, it would be considered extraordinary if I didn't realise that they do this kind of thing all the time. So then we're going to move on to paragraph 140. And this is a typically extremely long paragraph in which they waffle on for ages about various things. And I guess there's one statement I should particularly point out here, that indeed it does not appear to have been disputed that the more than 50 cases reviewed in the Lee and Tanswell paper were indeed all cases of air embolus in a neonate. Of course, that's incorrect. That's infamously incorrect. But this just goes on about various aspects of what occurred in court. And then it ultimately concludes, so too are the signs and symptoms which will or may be found. Expert evidence can be given as to those topics, and such evidence may assist the jury to determine whether an air embolus occurred in a particular case. So this is typical hiding behind the jury. Hey, all we do is put a load of information in a room and then the jury decides, and then we hide behind the jury decision. They will elevate the jury to a ridiculous degree. It really doesn't matter what the jury thinks. The jury went into this court case not knowing what air embolism even is, let alone are they in a position to scientifically decide whether or not it has occurred. But I'll read the last sentence. Although their direct clinical experience of air embolus in neonates was inevitably very limited, yes, each of the prosecution's expert witnesses was well qualified in their respective fields to give the evidence which they gave. Of course, this is debatable, but the court is emphasizing here that air embolism is a genuine medically recognized phenomenon, and that experts supposedly understand its mechanism, possible causes and signs, despite not having any experience. But the central dispute is not whether air embolism exists, it is whether the retrospective diagnostic method used reliably identified it in these babies, and indeed whether the diagnostic methodology is legitimate. This is, in common with so much that occurs in legal judgments, just a load of waffle that signifies absolutely nothing. It doesn't have any bearing on whether or not the observations made in court were legitimate, which of course we know that they weren't. So now move on to paragraph 142, in which the following is said. The real issue at trial was as to what signs and symptoms were sufficient to enable a reliable diagnosis of air embolus. We again observed that in his submissions to this court, it was at least tacitly accepted that cases noted in the Lee and Tanswell paper, which showed a type of skin discoloration other than bright pink vessels against a generally cyanosed cutaneous background, were indeed cases of air embolus. It follows that the differing types of skin discoloration observed in neonates in those cases were at least consistent with air embolus. So the court is reasoning here that because different skin appearances had been observed in air embolism cases, the appearances described at trial were compatible with air embolism. However, this is completely flawed because we know that there has to be a very specific sign, and there are biological and anatomical reasons for this. It's not just some observation of something that happened. The reason that it manifests in this way is due to biological factors that I'll discuss later in the video. So you can't start saying, oh, well, there are differing types of skin discoloration, but that's all perfectly fine. We'll just say that's consistent with their embolus. It's not. It absolutely is not. It cannot be. It never will be. So then we're going to move on to paragraph 143, which says the following: we see the force of the argument that the limits of scientific knowledge would not permit a reliable diagnosis of air embolus to be made solely on the basis of a particular type of discoloration other than the very specific type recorded in the Lee and Tanswell paper. We are not, however, able to accept the submission that that is what the prosecution expert witnesses did. So I don't think there was even the slightest chance that this appeal, leave to appeal, was going to be accepted, because it was too soon after a very high-profile court case and the court would have looked ridiculous. What I will say is that, assuming for the fact that judges aren't being deliberately disingenuous, that they just simply cannot understand what the prosecution expert witnesses have done. The court has essentially accepted that skin discoloration alone cannot reliably diagnose air embolism, and it's stressing that the prosecution experts had not purported to diagnose from colour alone. But the question is, firstly, is the discoloration evidence even legitimate, which is not? And secondly, whether adding other similarly non-specific findings transforms this combination into a reliable diagnosis, which of course it does not. Now, it's important to remember that Dr. Evans made his diagnosis according to his own account, although I think it's fair to say he's not the most reliable narrator at this point. But he claims that he made this diagnosis not even knowing about the discoloration and not knowing about the air in the infants. Now, this second point is actually true, as I'm going to demonstrate to you in a couple of months. We actually know that this is true for a fact. As with regards to the discoloration, considering that he definitely did put forward this theory without knowing about the presence of air, and considering he claims that he didn't know anything about the about the discoloration, one wonders on what basis that he's making this decision. Well, according to him, he made his so-called diagnosis of air embolism entirely based on the supposedly rapid collapse of the infants and the fact that they didn't respond to resuscitation. Those are his words, not mine. Given that this cannot possibly be used to diagnose air embolism, in order to make this unlikely diagnosis, it is necessary for there to be something of solidity to cling to. The only thing that they have, really, is discoloration, because they don't have x-rays for most infants. They don't have presence of air for most infants. So discoloration is really the only thing that even comes close to being meaningfully diagnostic. And this discoloration is repeatedly downplayed by this judgment. This judgment accepts that the discoloration was not used diagnostically directly and that it was only consistent with air embolism, as it states numerous times. So this is a classic house of cards in which inference is used with relation to all of the individual constituents, but none of those constituents have any solidity. It is therefore inevitable that the house of cards will collapse, as it has no foundation or substance. In the real world, it has already collapsed. It's only in the legal world where they have to pretend that what happens in a court has actual solidity, when it very obviously does not in the world of medicine and science. Now, paragraph 144 provides a classic example of the sort of things that are typically done in this verdict. So I'll read this out in full. Paragraphs 49 to 97 above summarise the evidence as to skin discoloration observed in the case of the babies who are the subjects of counts 1, 2, 4 and 16 and counts 3, 5, 12, 17 and 20, and the expert evidence concerning those babies. As is apparent, there are recurring features, for example, the sudden and unexpected collapse of a baby who was otherwise reasonably healthy, the failure of techniques of resuscitation, which could be expected to be successful if the cause was something other than air embolus, the dramatic and highly unusual changes in skin coloration, and the coincidence of other babies also suffering sudden collapses, most strikingly in the cases of twin siblings. So actually, I'll go on to read the remainder of it in a second, but let's look back at what is stated there. So it's the two things that Dr. Evans cited in his so-called initial diagnosis, the sudden and unexpected collapse of a baby who's supposedly healthy. Let's not go into the fact that they're not reasonably healthy at this point. And then the failure of techniques of resuscitation, which could be expected to be successful. Of course, Dr. Evans never examined these techniques of resuscitation, as I will examine shortly. Then the third thing is the discoloration that we know is wrong. And the fourth thing is that there is this coincident theory of all of the infants suffering sudden collapses, although they're not all sudden collapses. So if you take those things one by one, the sudden unexpected collapse of an infant cannot possibly be used to diagnose air embolism. The failure of techniques of resuscitation are simply because the quality of resuscitation on the unit was really poor. It's nothing. You can't take either or both of those things together to diagnose air embolism. That's just a joke. The skin discoloration that the Court of Appeal continually backs away from it and says, yeah, they were only saying it was consistent with, they weren't saying it was diagnostic. And as for the coincidence theory, all of these babies had very distinct clinical signs, so that's just complete crap. So those are the four pillars on which this supposed diagnosis is made, and none of them have any foundation at all. And then in the second half of this paragraph, they go on to discuss Dr. Evans and Dr. Bohin and their supposed diagnosis. As is also apparent, neither Dr. Evans nor Dr. Bohin diagnosed their embolus in any case on the sole basis of skin discoloration. No, they used those three other brilliant elements as well. On the contrary, each expressly disclaimed any ability to do so in any of the cases they were considering. See, for example, the summaries of these witnesses' evidence in paragraphs 52 to 54. Well, I'm not going to read all those paragraphs. And in particular, Dr. Bohin's explicit acceptance in the last of those paragraphs that a wide variety of skin discoloration had been observed, and that there is not one single thing that you can say is definitely pathognomonic of air embolus. So she has said quite openly, she hasn't really got a lot of choice, that there's a wide variety of skin discoloration. So that absolutely disqualifies this skin discoloration immediately. It should be gone immediately from this court case because it can't be even consistent with, let alone diagnostic. So what is the diagnosis based on? There were a lot of infants, they collapsed suddenly and they couldn't be resuscitated. It's air embolism, because we can rule out the skin discoloration completely based on what is stated here. But let's just finish this paragraph. The evidence that a particular baby had suffered an air embolus was in each case based on a combination of considerations. The careful submissions of Mr. Myers did not identify any part of the evidence in which one of those expert witnesses asserted a diagnosis based solely on discoloration. So this is all complete nonsense, basically. They're trying to put together what they describe as kind of characterized as a recurring package. But given that the skin discoloration is completely different, and the other supposedly diagnostic factors can't possibly be used to diagnose, this paragraph alone just discredits the entire diagnosis, just singularly discredits it. What the Court of Appeal has failed to do, which of course it doesn't do, because what it basically does is say our court and our system are both wonderful and we're going to defend our system and our court. But what it has not established is whether or not these individual components actually have any evidential, scientific or medical validity, which of course they do not. In this original Court of Appeal application, Dr. Lee is arguing from a scientific perspective, which with science, what happens in the real world is of critical importance. Whereas the Court of Appeal verdict is arguing from a legal perspective where only what happens in the court really matters. the court is able to completely ignore reality and then place what occurred in the court on a pedestal that supersedes actual science, actual medical evidence, and actual reality in the hospital. So let's have a look now at some cross-examination of Dr. Evans and what Dr. Evans said in court in relation to child B. Now, child B didn't pass away, whereas child A sadly died. So Dr. Evans has to try and give some sort of explanation for that. The explanation he came up with was that Lucy Letby injected less air into child B than child A, so therefore child B survived. There's no actual evidence for this, of course, but I want to go over this cross-examination so that I can show you what he said as well. So I'll begin here where it says, the little that there is in the literature says that the bigger the volume of air, the worse the greater the danger. The faster the volume of air is given, the greater the danger. And therefore, if baby B had a small amount of air injected into her circulation, and if part of this air was, it didn't all go in at the same time, then it helped save her life, plus the fantastic care she got off Dr. Lamy and others. So therefore, let's not use the word invariable. It's not a word that clinicians are very comfortable with. In fact, to be fair, when I asked you about the features of air embolus in your list of secondary features, you didn't say invariable, you said resuscitation is unsuccessful. That's why they die. Yes, but the fact that resuscitation was successful in the case of child B and there was a very quick recovery is utterly inconsistent with an air embolus, isn't it? That is incorrect. There are a couple of other cases where there are striking features consistent with air embolism where astonishingly the baby survived. We will discuss them in the next few weeks. Amazed they did survive, but that's a reflection. I think that's indication of the quality of resuscitation in this unit, by the way. So I'm going to continue with this cross-examination in a second, but bear in mind that Dr. Evans has just said that the quality of resuscitation on this unit was exceptional. Now, he has no way of knowing that because he did nothing to examine anything that occurred on this unit. And when I spoke to Dr. Shu Lee, who did examine this in great depth, he said something rather different. So in my book on the Lucy Letby case, there is a section in which Dr. Shu Lee goes through multiple resuscitations in the court case that were executed poorly. Now, bear in mind, I couldn't report back everything that he told me because it would have gone on, that chapter would have been 20,000 words. So I tried to indicate the extent to which there were problems with resuscitation while keeping it a manageable length. Now, I'm not going to even go over what I wrote in my book. That's all there in the public record. But I'm just going to recount this final paragraph where Dr. Lee says the following. So to claim that all of these resuscitations were optimal or even acceptable is untrue. Dr. Evans never cited any of these obvious errors while also claiming that every infant can be automatically resuscitated, and then he used this as his final criterion to diagnose air embolism. This is simply not tenable. So in the court case, he repeatedly, universally in fact, stated that all the resuscitations were great, when in reality, that's simply untrue. Also, he never made any criticisms of intubation, but it's very obvious that he just simply didn't look for these things. So let's return to his cross-examination. So I'll just briefly move on to the next bit of cross-examination so you can hear from this. Simply, baby B had symptoms and features consistent with an air embolism. Because she was on a unit where the staff knew how to resuscitate babies, she had the best chance and therefore recovered, which is great. But her original collapse in the first place is entirely consistent with air embolism. I'm sure you're noting all the features that I've discussed earlier in the video. And I reached that conclusion despite the fact that baby B and baby A were the first two babies I dealt with where the concept of air embolism and was an issue was relevant. There's not actually any diagnostic feature where child B is concerned that can show this is an air embolism, is there? She collapsed unexpectedly. Resuscitation took far more than you would expect. She had these astonishing skin descriptions. As we heard from Dr. Lamy yesterday, that adds to the clinical diagnosis she has an air embolus. Oh, so I'm going to finish off this sentence, but just take this sentence in. And I'm more than happy to hear anyone who says different from a medical perspective. So I'm not going to provide any further commentary on that. I think that speaks for itself. So move on now to paragraph 79, which involves Dr. Evans discussing a hemorrhage in relation to child E. Now, this is obviously not related to air embolism, but there's a reason that I'm going to read out this paragraph. Dr. Evans said that the hemorrhage was not the result of some naturally or innocently occurring phenomenon. Something had been done to baby E, causing the bleed and causing him to lose a lot of blood in a short period of time, sufficient to destabilise him generally. Initially, he had thought that the bleeding may have been due to the nasogastric tube, but having seen the type of tube which had been used, he did not think that it could have been responsible for the trauma. He thought that some other instrument had been used. He referred to something relatively rigid, such as a plastic tube used for suction or an introducer which is used to intubate a baby. He pointed to the fact that neonatal units are full of bits of equipment such as suction tubes or introducers which might have been used. Whatever it was, he said, there was no potential innocent explanation for the degree of bleeding seen. So, although this isn't related to air embolism, it is indicative of the same reasoning pattern, failure to identify a benign explanation sliding into an affirmative inflicted harm mechanism, which is at best highly speculative. I would say that it is complete rubbish. Dr. Evans cannot explain a physical phenomenon that is undeniable, so he has to invent a mechanism related to malfeasance. It's important to note here as well that the reason he can't give an explanation is simple lack of knowledge and experience. Others with greater knowledge and experience consider this to be absolutely straightforward, and that what Dr. Evans and Dr. Bohin said in court in relation to this infant is completely unfounded and frankly farcical. This is ironic because Child E was treated as one of the stronger cases in court when it's actually a very obvious gastrointestinal hemorrhage, and basically any doctor in the world will tell you that, certainly any with neonatal experience. So this is, as I mentioned, the same pattern we're seeing repeated with the air embolism cases, this time in Child E, where Dr. Evans still bizarrely, I would say stupendously, ridiculously suggested that this infant was suffering from an air embolism as well, and Dr. Bohin said that the blood was irrelevant. But let's not dwell on that too much because we're discussing discoloration at this point in time. The reason that Dr. Evans has never experienced this before and cannot understand why it's happened is twofold, and I'm being generous here when saying this. There are other conclusions that you could draw. This is the most generous conclusion that I can draw. Firstly, he doesn't have the background knowledge, and secondly, he doesn't have the background experience of working with medically threatened neonates. He simply does not have that clinical experience. That's why he should never have been in the court in the first place. Or rather, it's one of the reasons why he should never have been in the court case in the first place. You can see 14 other reasons on the screen right now, although that's not an authoritative list because there are other reasons as well. So then I'm going to move on to paragraph 187. This is a lengthy paragraph that I'm not going to read out in full. It's typical of the kind of waffly language that's used in these things, but it essentially asserts that Dr. Lee's fresh evidence was directed at the wrong target because the prosecution experts had not diagnosed air embolism on skin discoloration alone. They used different appearances merely as compatible features. So they're using this consistent with argument again, and then it really just repeats things that are said earlier. So I mentioned that the first approximately 9 pages of the Court of Appeal verdict are of no relevance to the appeal whatsoever. Also, a lot of the remaining 48 pages just repeat the same things over and over again. So this, again, just repeats over and over again. They didn't say it was specifically diagnostic. But that's irrelevant, as we've discussed earlier. The point is, the only really solid thing they've got in many, and indeed most of these cases, is skin discoloration, because the two other things, the infants collapse suddenly, even if that was true, when combined with the other failure to resuscitate supposed criterion, that is not enough to diagnose air embolism, obviously. And they don't have evidence of air, and they don't have x-rays in the vast majority of cases. There's only 1 or 2 cases where there's even an x-ray, and in the case of Child C, they had to move the date of the collapse and the date of the key supposed collapse away from the date of the x-ray because Lucy Letby hadn't had contact with the infant at the time that x-ray was taken. So this idea that, oh, well, it's consistent with air embolism, so Even though there's no solid diagnostic criteria, even though Bowen and Evans back away from this being a solid diagnostic criterion discoloration, and even though the discoloration is wrong, and even though it occurs in way too many cases, we're still just going to allow it anyway. So then finally, and arguably most importantly, the Lee sign that was established nearly 40 years ago now, that has never been contradicted, that cannot be contradicted because the science behind it is well established, was never seen in any of these infants. So this is what Dr. Lee told me and that I reported in my book. There are 3 kinds of skin discoloration described with air embolism. The most important is the Lee sign, which appears as bright red blood vessels superimposed upon a cyanosed or blue background. This occurs because in air embolism, air bubbles can block the blood vessels, leading to circulatory collapse, resulting in a shortage of blood going to the skin and organs and tissue hypoxia. This causes the skin to turn pale and then blue. Then, in air embolism, as the air bubbles travel through the blood vessels to the skin, the oxygen in the air bubbles oxygenate the red blood cells adjacent to the air bubbles. The red blood cells turn red, and this results in a pattern of red blood vessels spreading out from central to peripheral areas, resembling a tree. This lasts for just a few minutes because the oxygen in the red blood cells quickly diffuses out of the blood vessels into the surrounding tissue. The blood vessels then lose their red colouring and the patterning disappears after a few minutes. This phenomenon I have described has never been seen in any other condition, nor can it be explained by any other condition. That's why it's diagnostic of air embolism if you see it. So that is a perfect explanation of what you should see if there is discoloration. It's not really even, I think, accurate to describe it as discoloration. It's this very specific patterning resembling a tree with this pattern of blood vessels that are oxygenated in the way that is described. This is not described at any stage in the court case, and yet discoloration is cited over and over and over again, despite his claims, including by Dr. Evans. What the problem is, the fundamental problem is, that the Court of Appeal simply didn't have the knowledge, understanding, expertise and competence to recognise this. In summary, the Court of Appeal verdict fails to understand or acknowledge that unexplained collapse is not a diagnosis. Sudden collapse and poor response to resuscitation, indeed, do not establish a valid diagnosis of air embolism, as is repeatedly asserted. The court accepted that the discoloration was not diagnostic of air embolism, only consistent with it, but this feature can be compatible with many competing conditions. Consistent with is repeatedly treated as though it adds affirmative diagnostic weight. Any medic will tell you that the real question should be how strongly a feature discriminates air embolism from alternative causes, not merely whether it can occur in air embolism, which is a highly unlikely diagnosis. Dr. Jayaram's recollection of skin discoloration was not recorded contemporaneously. The court seemed to have little understanding of this. The verdict seems to argue that Letby was required to establish the true natural cause of every collapse. It is not clear why this is the case. To the layman, surprising comments about Dr. Lee's evidence are, at best, extremely curious. Evidential bootstrapping from the Court of Appeal is tangible, tying together multiple weak propositions in defence of the conviction. The Court of Appeal seems to have no understanding that both the observable type and frequency of discoloration are among critical reasons why evidence provided in court has no credibility. There is considerable confusion over the term diagnosis of exclusion and why this shouldn't be used to diagnose air embolism. So that brings us to the end of this first part of the analysis of the Court of Appeal document. Although discoloration is a significant component of the Court of Appeal verdict, there is a lot more to go through as well. So I will continue analysing the Court of Appeal document in a video next Sunday. I hope you've enjoyed this initial foray into this rather confusing and curious document. If you have any comments, queries or observations, please do leave them in the comments section. Thank you for watching.